appeal in the matter of G Fry Son Ltd and the Secretary of State of levelling up housing in communities in Medina.
Mr. Mills, we note the absence, and we of course regret the absence of Lord Banner, who's unwell this morning, as you've kindly told us. I'm very sorry, we're all very sorry to hear that. The arrangements suggested in the email that you kindly sent, or Dr. Bose sent actually, was that there would be a written reply, as I understood it, in the course of the day. Is that right?
Yes, indeed, Lord, yes.
And that this, subject to instructions, was not opposed.
It's not opposed. I have instructions and I don't oppose that.
As do I, my lord. My instructions are not to oppose as well.
All right, well, fine. We've got to set a timetable for that. Probably the right thing to do is to set that timetable at the end of the hearing rather than at this point. But in principle, we accede to that request, and we'll make arrangements at the end of the hearing for the reply. But we will, I think, be requiring the reply in the course of the day today.
I'm very grateful. I'm sure it's Lord Banner as well, my lords.
Yes, and we wish him a speedy recovery, obviously.
As do we all. Thank you, my lord. So, picking up where I left off yesterday, I had taken the court to the Court of Justice's judgment on the preliminary reference in Barker.
Yes.
Now we're going to go briefly to tab 15 of the authorities, which is the House of Lords judgment following that Court of Justice ruling. It's tab 15, and if I could ask the court to go to page 236, which is the speech of Lord Hope. So at the foot of 236 in paragraph 5, Lord Hope notes that the effect of Regulation 4.2 of the EIA Regulations 1988 was that where outline permission was being sought, an EIA can only be required at the stage when an application for outline planning permission is being considered, and that is because the 1988 regulations only refer to decisions to grant planning permission. There was no provision in those regulations enabling the authority to call for an EIA at a later stage. He goes on to say, in many, if not most cases, that will not matter, because the environmental effects can usually be sufficiently assessed at the outline stage. And then I rely particularly on the next passage, but it is possible to conceive of cases where they only become apparent when consideration is being given to the reserved matters, and I emphasise, or where further consideration is necessary due to a material change of circumstances. And as my lords would have appreciated, the respondent's case is that here there was a material change of circumstances following the outline permission, namely the Natural England note in relation to the Ramsar site. So 2 points just on paragraph 5. Firstly, the emphasis on material change of circumstances being capable of triggering further or EIA for the first time. The second point is that the 1988 regulations didn't contain an equivalent of Regulation 63. As I'll show my lords, what Regulation 63 does is faithfully transpose the Article 6.3 obligation, and the rest of the regulations in my submission are machinery around to secure the operation of that obligation. There was no direct transposition in the EIA regulations of the obligation to conduct an EIA before granting development consent. My submission is if there had been, then the result of Barker would not have been a declaration that there'd been a failure to transpose. The 88 regulations would simply have been construed as requiring EIA at the subsequent consent stage. So that's the difference between the outcome in Barker and...
Mr. Mills, that's consistent, if I may say so, with how I've always understood the nature of the exercise that one has to perform under EU law when it comes to directives.
Indeed, my lord.
And that's why, and it may not matter at the end of the day, but that's why I've, speaking for myself only, been a little puzzled as to why the judge in the present case started talking about direct effect, because I don't want to be unfair, maybe I'm misunderstanding the point, but I thought the strict legal position is that in the case of a directive, you don't reach the concept of direct effect unless and until you've first gone through the process of compatible interpretation.
Precisely.
It's only if there's a failure faithfully to transpose a directive into domestic law that one then reaches the doctrine of direct effect.
That's exactly right, my lord. And leasing is a strong interpretive obligation, so one shouldn't readily get to the conclusion that there has been a failure to transpose because the leasing.
And the starting point, getting back to 1963, the starting point was the directives didn't have direct effect, unlike regulations. The whole point was that it took a development in the case law with the early jurisprudence of the Court of Justice. And the reason they said that they could, in principle, have direct effect was what they called a principle of estoppel. That if the member state has failed faithfully to transpose a directive into domestic law, then it can't rely on its own failure to say, well, you can't rely on this directive, etc.
Exactly, my lord, yes. So just moving on within the speech of Lord Hope to page 240, beginning at paragraph 16, under the heading of the classification issue, Lord Hope summarises the Court of Justice ruling. I just asked the court to note over the next page, paragraph 19, where he specifically notes the Court of Justice's rejection of the UK argument that the outline permission was the consent. And then at paragraph 21 on page 242, we see that the UK accepted that the regulations failed properly to transpose, and that's because they overlooked the fact that the consent might be a multi-stage process. The emphasis in my submission in paragraph 21 is on the fact the approval is needed lawfully to continue the development. The emphasis isn't on the fact it was a reserved matters and there's something special and distinct about reserved matters. It was the fact that the reserved matters was the implementing decision. And so in my submission, the reasoning of Barker applies equally to a pre-commencement condition where, applying the Whitley principle, approval is required lawfully to implement the development. And the final part of Lord Hope's speech I invite the court to read is paragraph 24, beginning at the foot of page 242. If I could just ask the court to read that paragraph in full, please.
24.
24, my lord, thank you. And I emphasise in particular the penultimate sentence, account must be taken of all aspects of the project. Again, a clear signal that the appellant's ground 3 in this case is contrary to authority. The assessment at the reserved matters stage isn't confined to the reserved matters, it's the impact of the whole project which falls to be considered. So that's the background on the interpretation of development consent in the EIA regime as including implementing decisions at the subsequent consent stage. I now want to look at the jurisprudence on Article 6.3, which draws on that jurisprudence in the EIA context to determine what agree means in Article 6.3. The first case is tab 27 of the bundle, Friends of the Irish Environment. And the court has already seen the basic issues and facts. If I could pick the judgment up at page 587 of the bundle, paragraph 40, which is where the court begins to deal with whether the consent in that case constituted an agreement of the project. So that's paragraph 40 on page 587. And at paragraph 42, the Court of Justice notes that the Habitats Directive does not define the conditions governing how authorities agree to a given project under Article 6.3, but citing Inter-Environment and Wallonie, they hold that the definition of development consent is relevant in defining that term. And then they quote in 43 the definition in the EIA directive, which we know from Barker has been construed as including the implementing decision at the subsequent consent stage. So not only the wording of Article 1.2 being held to be relevant in my submission, but also the jurisprudence surrounding the interpretation of what that term actually means. Then at 44 to 47, in my submission, what the Court of Justice is doing is simply applying that principle to the particular facts of the case. But the principle is not confined to consents that have lapsed and a new consent being sought. It's not possible to distinguish Friends of the Environment, Irish Environment, on that basis. Yes, it's true that's what the facts of the case were about, but the Court of Justice is clearly saying, as a matter of principle, one should define agree by reference to the case law and the directive on development consent in EIA. It's true that the court did say EIA is relevant to the meaning of agree, as opposed to saying they are the same thing. But in my submission, there is no good reason why the multi-stage consent process reasoning should not apply equally to Article 6.3 of the Habitats Directive. The analysis in Friends of the Irish Environment, paragraphs 44 to 47, is all couched in terms of whether the consent was needed to proceed with the works. And that is obviously redolent of the analysis in Barker. And the expression in the directive, Article 6.3, is agree, and that naturally, in my submission, encompasses an implementing decision, i.e. the final consent required in order for lawfully to proceed. And further, on a purposive interpretation, agree should encompass the implementing decision when one is dealing with a regime which is about substantive environmental protection on a strict precautionary basis. One would expect in a regime of that kind that the precautionary test bites on the final authorisation rather than
Yeah, I mean, on the first point you made, one notes that the way it's expressed at paragraph 47, they say a consent such as the consent at issue in the main proceedings does constitute a new consent under the EIA directive and consequently also an agreement under Article 6.3. So the Court of Justice is translating the definition that's applicable under the EIA as being translatable to the question of agreement under Article 6.3.
It is, my lord, and it would, in my submission, given the nature of the Habitats Directive, be surprising if a project were, well, if something were a development consent for the purposes of EIA, but not an agreement for the purposes of habitats. I can see no principled reason why one would be in that scenario. Then the next part of the Court of Justice's judgment that is relevant to these proceedings begins on page 588 under the heading the third question. And this is relevant to the ground 3 issue, what must be assessed. So at paragraph 49, we see the third question the court was dealing with is the conditions for applying the requirement to carry out an appropriate assessment. In particular, is the authority required to take account of any changes to the works originally permitted, as well as the environmental background and changes in scientific knowledge. At 52, the court applies the well-known principle that the appropriate assessment must consider all aspects of the project or plan, individually and in combination, in the light of the best scientific knowledge. And it goes on at 53 to say the assessment can't be regarded as appropriate if it has gaps, lacks complete, precise, definitive findings and conclusions capable of removing all reasonable scientific doubt. And at 54, it explains that one can take account of earlier assessments to avoid duplication. But at 55, that's qualified by the fact that you can only take account of previous assessments to the extent they actually rule out the risk. If they don't, that doesn't obviate the need for further assessment. And so in my submission, that again is reinforcing the point I made in relation to Barker. The assessment must be of the effects of the whole project, rather than simply the application that is before the decision maker. And importantly, the further assessment can be where there has been a change to the environmental background, and that's obviously what, or at least the scientific understanding, that's what the Natural England note represents. It's the material change of circumstances referred to by Lord Hope, and it's the change in scientific knowledge, the environmental background referred to in Friends of the Irish Environment. The next authority I just want to touch briefly on is in tab 26, and that's the Inter-Environment and Wallonie decision. The relevant part is at paragraph 140, which is at the foot of page 554. So the question here is when should the assessment take place? And on the next page at 142, the Court of Justice notes again that the Habitats Directive doesn't define what is meant by agree, but draws on the definition of development consent in defining that term. And then its finding in 143 is if national law provides for a number of steps, Article 6.3 should in principle be carried out as soon as the effects on the protected site are sufficiently identifiable. And my learned friend relied on 143 to say that sort of endorses front loading. In my submission, in 143, the Court of Justice is not prohibiting appropriate assessment at a later stage. The conclusion that appropriate assessment should occur at the earliest stage was by express analogy with the EIA directive, which says in terms the assessment should be at the early stage. But Barker shows even in that context, where there has been a failure to do it properly or a material change of circumstances, EIA can be required at the subsequent stage of the
So, as I understand it, what you say is the fact that you should do it as soon as possible doesn't mean that if you haven't done it earlier, you shouldn't do it later.
Precisely, exactly. It's non sequitur to draw that conclusion from 143.
I noticed that the authorities do not include this court's recent decision in the Sizewell C case. Is that of any relevance here?
We can certainly check that off the top of my head.
I may be misrecalling, but maybe
we will certainly check that, and if there is anything of relevance, draw that to the court's attention during the course of this morning.
Yeah. I'm not suggesting there is. I'm simply putting the thought out there.
We'll investigate and come back to you if that's acceptable. So in my submission, Article 6.3, correctly interpreted, having regard to the EIA cases, means that there is no agreement until the implementing decision is made, which is the decision allowing the developer to proceed. And that is how, in my submission, the domestic courts have interpreted this jurisprudence in both Wingfield and Swire. I can go to those very, very briefly. Tab 23 is Wingfield. And the 2 points I really wish to make by reference to this. Firstly, Mrs. Justice Lang didn't regard that conclusion as being a clash with the principle of formal validity. She expressly refers to Noble, and I'll show my lords that. And then the second point is Mrs. Justice Lang's interpretation of Article 6.3 agreement is consistent with the submissions I've been making. So, picking the judgment up at page 391, paragraph 57, the court can see that the claimant argued that the council in that case had breached EU law by failing to conduct a habitat regulation assessment before granting outline planning permission.
I'm so sorry, it's my fault. I'm not in the right tab.
Oh, sorry, my lord, it's 23.
Oh, thank you very
Slide 23, paragraph 57 at the foot of 391.
Thank you.
And the last 4 words of 391, it was submitted the effect of people over wind, the judgment of the Court of Justice, was to render the outline permission a nullity, which couldn't be relied on. And the claimant's alternative submission was that the council ought to have revoked the planning permission. At 58, the last 4 lines, the council submitted that the consent was valid and unless until quashed, and it was lawful to conduct the HRA at the reserved matters stage. So directly an issue was a submission about formal validity and what that meant, where there had been a failure to conduct an appropriate assessment. At paragraphs 60 and 61, Mrs. Justice Lang noted that somebody could have applied for judicial review of the outline permission within the time limits, but had not done so. And at 63, she then rejects the submission that the outline permission is a nullity, citing the familiar authorities of Smith and East Ello and Noble. So nothing in her judgment purports to detract from those principles. She goes on, however, to deal with the question of whether it's permissible to have reserved matters appropriate assessment. She, at 67 on page 394, draws the analogy with the EIA directive and the Barker decision. The reference she gives to the Commission in UK is to the infraction proceedings element of Barker. She quotes at 68 Lord Hope, the paragraph in his speech at 24 that I took the court to earlier, and in light of Barker, she concludes at 69 it's wrong to suggest the only time in which one can have an EIA at reserved matters is where the effects were not identifiable. It's also possible where they've been overlooked, or as per Lord Hope, paragraph 5 of Barker, where there's been a material change of circumstances. And then at 70, she applies that principle to find that on the facts of that case, appropriate assessment had been overlooked at the outline permission stage. So at 71, the council lawfully could conduct an appropriate assessment. At 72, she says there's no stated purpose in the Habitats Directive of a assessment at the earliest opportunity. In my submission, that's not a key plank of the reasoning. The ratio of the decision is that, by analogy with EIA and Barker, agreement is the implementing decision, and one gets that from 74. Midway through, in a multi-stage consent, there is no agreement to the project until the reserved matters has been granted. So the fact that subsequently, a few days later, in Inter-Environment and Wallonie, the Court of Justice did say an appropriate assessment should be carried out at the earliest opportunity, none of that detracts from the actual ratio of Wingfield, which is that one looks for the implementing decision, and on the facts of that case, it was the reserved matters.
Certainly I would benefit from your assistance with this. How does this actually sit conceptually with what the judge had recognised in Wingfield at paragraph 63, which is the well-known principle in Smith and East Ello at Noble? I mean, those decisions are binding on this court.
They are, my lord.
Wingfield is not. So I mean, is this doing any more than paying lip service to that principle? So if those decisions earlier in the process have not been challenged within time, then what's going on here? Why aren't they presumed to be valid in law?
They are valid. They are presumed to be valid. What's going on is, as the Court of Justice explained in Barker, the project is not entirely authorised because there is another, in order to lawfully proceed, there is another consent required. And in refusing consent to that implementing decision on habitats grounds, one is not questioning or collaterally challenging the earlier decisions. One is simply exercising the discretion to withhold consent for a further element of the
Well, I understand that's how it's put, but I'm just wondering what's really going on here, because what Lord Banner submitted yesterday was that not only had the outline planning permission been granted, but various conditions had then been met. Various things had to be put forward, including in relation to wastewater. And when you looked at what was left, it was no doubt important, but it wasn't to do with, for example, wastewater. It was to do particularly with surface water. Now, he may or may not be right about that. Let's assume that he's right about that as a matter of fact.
Yes.
Then it is striking, if you're right, and you may be right, that in law, a local authority can, as it were, reopen issues which it's already signed off on.
Well, in my submission, there are careful limits on that. One is then into the territory of paragraph 5 of Lord Hope's speech in Barker. It's not free rein to reopen those matters. One has to look for either the matter being overlooked or there being a material change of circumstances. And in my submission in this case, the discharge of condition 7 relating to foul water on the outline permission, the date was 2018, the precise date was 15th of February 2018, and the Natural England note was in 2018, so some 2 years after. So that is, in my submission, a classic example of a material change of circumstances, a change in the environmental baseline, and it is that which justifies the taking into account of habitats issues at the further consenting stage, because the development is not entirely authorised as a matter of domestic law. So that is how I rationalise that result.
So that's a material change in circumstances.
It is, my lord, yes.
But absent that, the argument would not be available to you on the facts. Yeah.
Well, indeed, yes, that's right. I'm certainly not submitting that, that there is carte blanche at the reserve matters or the condition discharge stage to revisit. And that's what we saw when we looked at the Friends of the Irish Environment. One can look back at earlier assessments if there have been any, and that is sufficient, providing things haven't moved on, and that is no longer sufficient on a precautionary basis to exclude the risk. And in the ordinary run of events, there won't be a material change of circumstances. This is a case where Natural England didn't appreciate the risk to the Ramsar site until Dutch nitrogen was handed down. Once the consequences of Dutch nitrogen became apparent, the risk was on the radar for the first time midway through the multi-stage consenting process. And my submission is that in legislation which has a strict precautionary purpose, the legislature intended that matter to be capable of being addressed before the pass is sold and the implementing decision is agreed to.
No.
Just returning to Wingfield, in my submission, it doesn't matter that was a reserve matters case as opposed to a conditioned discharge. The analysis in paragraph 74 is whether there is agreement with the project in the sense of allowing it lawfully to proceed, and that's the critical point. My Lord, the Senior President yesterday asked a question about the enforcement provisions in the Town and Country Planning Act and whether the concept of unauthorised was a feature of that. The answer is not in the statute itself. We've got copies of the provisions which we can provide, but in short, section 171 capital A uses the concept of breaching planning control, which has two aspects to it. Firstly, development as defined in section 55 without planning permission, but secondly, failing to comply with the conditions or limitations. So it's the concept of breach of planning control which is critical. However, that the language of unauthorised does feature in the jurisprudence, most notably in Whitley, which the court has in tab 11 of the bundle. And the key passage of Lord Justice Wolfe's judgment is on page 128. So tab 11, page 128. Picking the first main paragraph up at the end of the fifth line, where he says, as I understand the effect of the authorities, to which he was about to refer, it's only necessary to ask the single question, are the operations, in other situations the question would refer to development, permitted by the Planning Commission read together with its conditions. The permission is controlled by and subject to the conditions. If the operations contravene the conditions, they cannot properly be described as commencing the development authorised by the permission. If they do not comply with permission, they constitute a breach of planning control, which is the statutory concept. Then he goes on to say, and for planning purposes, will be unauthorised and thus unlawful. So
do I understand it? I mean, to give an example from a rather different context, but one with which I'm a bit more familiar with, if permission to appeal to this court is granted subject to compliance with a condition, and the appellant doesn't comply with the condition, they have no permission to appeal.
Exactly, my lord. Yes, that's right.
Is that essentially the same reasoning?
Exactly the same reasoning, my lord. Yes.
So the language of authorised and unauthorised comes back at the end of that paragraph you've just taken us to.
That's my lord, I'm grateful, yes.
I mean, authorised by the planning permission, those which are unauthorised,
So
because they contravene conditions contained in the planning permission.
That's correct, my lord. So although section 172 of the Act talks about the ability to impose conditions to regulate the development, the jurisprudence on the interpretation of the Planning Act holds that a pre-commencement condition is a necessary authorisation for the development. So it doesn't matter in my submission then that Wingfield was a reserved matters case. It was an implementing decision needed lawfully to authorise. Also doesn't matter in my submission that it was agreed in Wingfield that there would be an appropriate assessment. So as the court saw yesterday, the developer voluntarily put one forward and the council took it into account. That obviously wouldn't confer jurisdiction on the local authority to consider the matter. And in paragraph 74, Mrs. Justice Lang was clearly regarding that as something that lawfully could be required, whether it was done by agreement or not. The court has Swire in the bundle. We went to it yesterday. I don't think we need to turn it up. It's tab 32, paragraph 94, which is the key passage. And in my submission, Mr. Justice Holgate's reading of the ratio of Wingfield is correct, and as per my submissions that I've just been making. The other line of jurisprudence that's...
Sorry, just on that point, he cites a weekly law report as saying that permission to appeal was refused in Wingfield. Now, I'm not doubting for a second that he's right about that, but we don't seem to have it in the bundle.
We don't. We can provide that permission decision.
Yeah.
From recollection, my lord, there were I think 2 applications for permission. One I think trying to gainsay the first refusal and argue it didn't properly take into account what was the subject matter of the application. So I think that's the recorded decision about the proper ambit to revisit a refusal of permission. But we can look at that, and if anything's material, provide it.
Well, just pursuing that point, I mean, I'm not intending to be critical. I mean, I appreciate the the way things are done. But I'm guessing that Mrs. Justice Lang's decision in Wingfield is reported at that place in the WLR, and what one has in the usual way is that at the end of the report of the decision you get what happened on the PTA application. But what we have in the bundle is not the law report, despite what the practice direction says.
We can certainly check.
If the practice direction had been complied with, we would have had it.
My recollection is it's not Mrs. Justice Lang's decision that's reported, but
Oh, really?
only the Court of Appeal's judgment on the conditions for
Oh,
reopening.
I see. All right.
Because
Well,
you're-
I'm over-interpreting it. That's
I
my
think
fault.
actually it was a decision of my Lord the Senior President with Lady Justice Andrews and Lord Justice Coulson. It turned on the construction of CPR 5230 sub 1 for reconsidering refusals of permission to appeal, and it's that
Oh,
judgment
right,
that's
I see.
reported rather than.
Okay, so I was making an assumption which was not justified. Thank you.
And I have to say, I simply hadn't recalled that. When was that decision?
27th of November 2020.
Nearly 4 years ago, my Lord, so there's no reason why you would recall it. But I'll ask Mr. Grant just to read that, and if there's anything in it that's relevant to these proceedings, I'll obviously draw it to your attention. But
That was a refusal of permission.
it was, and it was a
Refusal to reopen.
it was a refusal to reopen, a refusal of permission.
Oh, I see.
So the question was the ambit.
Yes,
of the rule
no, I
of
do
CPR
remember it.
52.
It was it was one of those cases in that jurisdiction. Yes. Yeah, I understand.
I next wanted to go very briefly to the other line of cases that in my submission are relevant to the interpretation of the legislation, and that's the cases on the precautionary principle, which I can take very briefly, so I expect this is all familiar territory. Wyatt is a helpful introduction. It's tab 33 of the authorities. This is a post-EU exit day decision. And paragraph 9 sub 6, which the court will find on the foot of page 888. My Lord the Senior President explained that Article 6.3 and Regulation 63 sub 5 embody the precautionary principle. So clearly when construing them, it's a relevant principle to use. The other point to note on the preceding pages is that paragraph 7 and 8, my Lord set out Article 6.3, and then at paragraph 8 noted that the obligation in 6.3 was transposed into domestic law by Regulation 63. And I'll develop this when I look at whether the construction I urge on the court is contra legem, but the substantive obligation, the vehicle for transposing that is Regulation 63.
That's at paragraph 7, is it?
It's paragraph 8. My Lord sets out
Paragraph
the directive at 7 and then refers to that provision being transposed by Reg 63. Last two cases, very, very briefly. Tab 25 is Dutch nitrogen in the Court of Justice. It's starting at tab 25, page 474. We see at paragraph 95 the statement of principle that the appropriate assessment of the implications of the plan or project implies that all aspects of the plan or project, which can individually or in combination.
I beg your pardon, could you give me the paragraph number again?
Certainly, my Lord, it's 95.
Thank you.
So appropriate assessment implies considering all aspects of the plan or project, which again in my submission is fatal to ground 3. That is because at 98 we see that the assessment can't have lacunae, it must be complete, precise, contain definitive findings, capable of removing all reasonable scientific doubt. That is a specific application of the precautionary principle. And at 100, we see the Court of Justice explaining that Article 6.3 thus integrates the precautionary principle. It's about preventing in an effective manner adverse effects, and a less stringent authorisation could not ensure effectively the fulfilment of the objective. Again, in my submission, that is fatal to the submission by the appellants that it's permissible and within the procedural autonomy of the UK to front-load the assessment. That would clearly lead to the sort of lacunae that Lord Hope talks about in Barker. That should be avoided a fortiori when one is dealing with substantive outcomes, as the Habitats Directive does. Last case on precautionary is tab 31, Harris, the decision of Mr. Justice Johnson in the High Court. The point about this is it's not just Article 6.3 that embodies the precautionary principle, there's a treaty provision as well, and it's set out at paragraph 42. 42, my lord, on page 822. So it's Article 1912 of the Treaty on the Functioning of the European Union, and that provides that EU policy on the environment should aim for a high level of protection and should be based on the precautionary principle. And that leads the judge over the page on...
Well, can I just ask about that? That seems a bit strange as being something being relied on post-Brexit.
The treaty provision.
Yeah. It's no longer a source of law in this jurisdiction, is it?
I don't think the way I would rationalise it, my lord, is not the treaty provision, but the policy that's been generated pursuant to that provision. When one looks at that, or construing legislation in that policy context purposively,
that seems a bit constitutionally dubious.
I don't need
at the moment.
I don't need that for my submissions. Article 6.3.
I mean,
TFEU is not part of EU retained law,
It's
and
not retained.
deliberately not.
Indeed, my lord.
So
At paragraph 59 on page 825, Mr. Justice Johnson said that the precautionary principle is a retained general principle of EU law, and cited for that proposition section 6, subsection 7.
Indeed, that was my next port of call, my lord. So that's helpful. Thank you. So in my submission, one sees the precautionary principle across all sorts of areas of EU law, in the reach and authorisation of chemicals, agriculture, product liability, etc. And it's got specific legislative base in Article 191, which I agree with my lord's question. That is not incorporated through the Withdrawal Act.
so the treaty subsists to that in that way. Is that what is being suggested?
I think, my lord,
Article 191 of the treaty has...
So is this one of these scenarios where the TFU is actually a codification of what
of a general principle of
had
EU
already
law?
been recognised as a general principle?
Precisely, my lord, and the peg to incorporate that is section 6.7 as a
Yeah.
general principle of EU law. One of its manifestations is that the treaty article.
Yeah, and that subsists post
General principles of
EU
EU law
exit.
do. That's right, not the treaty provision,
Yeah.
But the general principles of EU
Although
law.
that's now, of course, been abolished by ruler.
It has, my lord.
That doesn't apply in arguments.
Exactly, my lord.
Yeah.
Right, so proceed with care is really something we should note for those paragraphs, is it?
Well, in my submission, 59 is correct. 42 is an observation, but I don't read the judge as saying I can rely on the precautionary principle because of Article 191. If that's what he was saying, I agree with my lord, that would be wrong. It's an aside as to where the precautionary principle features in environmental law.
But 59 is safe.
59 is safe because there's a general principle of EU law, which is the precautionary principle, Article section 6.7 of the Withdrawal Act, gives express authority to have regard to it. in any event, it's embodied, as my lord held in Wyatt, in Article 6.3 and Regulation 63. So that's the most direct route into that conclusion.
It's not contentious here, though, as I understand it, as a principle.
It's not, my lord, no. So in my submission, interpreting agree as including the implementing decision in a multi-stage consenting process does give effect to the precautionary principle and the purpose of the legislation. Contrary to the appellant's case, the timing of the assessment does matter. I've made my point about procedural autonomy not allowing front-loading where that would give rise to a lacuna. In Barker, it wasn't within the procedural autonomy of the UK to say that EIA could only occur at the initial stage, the planning permission or outline stage. That would have been a complete answer to the case, but as we saw, that was rejected.
Mr. Williams, I regret to say that I haven't yet studied Mr. Justice Johnson's judgment with the care that I will need to. But can you just help me before we leave this judgment? I noticed that at page 831, when he's considering issue 2 in the report, he addresses the question, are the obligations under Article 6.2 recognised by a court before 2021? In other words, he's addressing the section 4.2b question.
He is, yes, my lord.
And I think he's, yesterday we were told by Lord Banner that he held that, I forget which provision, in the directive, what did have direct effect.
Article 6.3.
Article 6.3. It's again, it may be that I'm missing some crucial point of what's going on here. Why are first instance judges going to the doctrine of direct effect and asking themselves the section 4.2b question, when I thought your fundamental submission, at least to this court, is that the directive has been faithfully transposed into domestic law by the regulations? Am I missing something crucial in the reasoning?
No, my lord. I think the way the case was put in Harris, if it would help, my lord, I can go through Harris in a bit more detail, if that would be of assistance.
I know time is limited.
Just before we get into the detail, I mean, he's addressing Article 6.2, whereas we're concerned with 6.3. Is Article 6.2 implemented in the regulations? When Article 6.3, your case you've made very clear, and I'm not sure it's really disputed, is at least purportedly implemented by Regulation 63.
Yes.
But where is Article 6.2 implemented in the regs, if at all?
So
is that why he's addressing the question?
In part, so it might help to have Article 6.2. It's set out at 46 of the judgment on 822. It's the obligation to take appropriate steps to avoid the disturbance of habitats and species. And so that's partly implemented through the review provisions, which we see in the 2017 regulations, so the review of existing consents. So something that's already been agreed doesn't fall within the scope of Article 6.3 because the consent has been given. But if harm is being caused or risks being caused to a habitat site, there are provisions in the 2017 regulations allowing those consents to be reviewed, if necessary, amended or revoked.
Just skim reading what Mr. Justice Johnson says, the case seems to have proceeded on the basis that the Article 6.2 wasn't, at least clearly, implemented in the regulations. And so the claimant's argument was reliant upon direct effect.
It was, because the obligation in 6.2 doesn't bite at a particular point. It's a general obligation to avoid. It's potentially partly implemented through the review provisions. The obligation, there was a lot of consideration of Regulation 9, the duty in exercising functions to have regard to compliance with the directive. And so I agree with my lord that recourse to direct effect in that case was potentially plugging gaps in the regulations where they don't expressly provide for all the various ways in which it could be said a member state ought to be avoiding harm where one isn't in the territory of a consent that Article 6.3 bites on. So in answer to my Lord Justice Singh's question, I think that's why direct effect was relevant in that case.
Yeah, that does, I agree with my lord, that does appear to be how the arguments were being put to the claimant in that case at paragraphs 63 and 64. I think, as I say, it may not matter at the end of the day, because you have very clearly submitted to this court that on your submission, the relevant provision in the Habitats Directive, Article 6.3,
Yes.
has been faithfully transposed into domestic law by the regulations.
Indeed.
And so you're very clear in your analytical framework that one does not need to, and indeed does not reach the stage of asking, does it have direct effect?
Precisely, my lord, yes. And when one looks at Harris, the first plank of the claimant's argument was that Regulation 9, the duty to have regard to the directive, did the heavy lifting, and that was a sort of complete transposition.
And just to be clear conceptually why this may matter, if you're right about that, and I'm not saying whether you are or not, but if you're right about that, does it follow that this court need not concern itself with the concept of the same kind in section 4.2b?
It does. It does. As I submitted at the outset, there were three routes really into my construction of the regulations: domestic interpretation, combination of sections 2 and 6, and the reliance on retained EU law to construe the regulations which were purporting to transpose the directive. It's only if any of that is contra legem that one would even need to get into direct effect. On my submissions, one doesn't get that far. And I'll now come to why it's not contra legem to construe the regulations in the way I submit they should be. But I've got just eight short reasons why it is not contra legem. First is there's no express prohibition in the 2017 regulations on conducting an appropriate assessment after the grant of outline permission.
Just take this slightly more slowly, if you would, for me.
I'm sorry, my lord. So first is no express prohibition in the regulations on conducting appropriate assessment after the grant of outline permission.
Yeah.
Secondly, Regulation 70 sub 3 can properly be regarded as an extending provision, i.e. making clear that the outline stage is not too early to conduct an appropriate assessment. Thirdly, most fundamentally in my submission, the regulations need to be interpreted in the light of Regulation 63, which is the key provision transposing the relevant obligation in Article 6.3. As I showed the court in Wyatt, paragraph 8, that is the role of Regulation 63, to transpose Article 6.3. And as my Lord Justice Arnold observed yesterday, the words in Article 6.3, authorisation, permission, etc., are all synonyms. They're also synonyms of agree, which is the term in Article 6.3, which Reg 63 was trying to transpose. It's trying to express in domestic law all the various forms of agreement one can conceivably think of. So with the keystone being Regulation 63, Regulation 62 and chapters 2 to 7 shouldn't be read as restricting the scope of that obligation that's been correctly transposed.
Is this still point 3? Or
this is still point 3.
Should not be read as
restricting the scope of the obligation that Regulation 63 transposed, rather in light of Reg 63, they should be read as making specific provision for the discharge of that obligation in particular contexts. Just to give the court an example, Regulation 75, which is tab 5, page 62, this deals with
70 sub 5.
Regulation 75, sorry.
Oh, 75.
Number 75, yes.
Yeah.
It's page 62 of tab 5. So this is dealing with general development orders, so things like the general permitted development order which grant planning permission.
Page, sorry.
Page 62, my lord. So what Regulation 75 does is deem it to be a condition of any planning permission granted by development order, so not on an application but through the GPDO, that it's deemed to be subject to a condition that development which is likely to have a significant effect on a European site must not be begun until prior approval has been granted by the local authority. So this is, in my submission, the mechanics of working through the obligation into the specific consenting procedures. It's seeking to expand and catch all scenarios rather than to restrict the obligation. There's nothing in the wording of chapters 2 to 7 to indicate that Parliament was intending to limit the obligation that it correctly transposed in Regulation 63. That's reinforced by Regulation 62(1)(b), the assessment provisions applying to all other plans and projects not relating to those chapter 2 to 9 matters. That's broad inclusionary language. Consistent with my submission, the intention wasn't to cut down the correctly transposed Regulation 63 obligation. So that was my third point, the importance of Regulation 63 and the need to read everything else in the light of what it does. My fourth point is Regulation 9 of the 2017 regulations. That's tab 5, page 29, or page 28, sorry. So in 9.1, the appropriate authority must exercise functions which are relevant so as to secure compliance with the requirements of the directive. And then when we get to the competent authority, so granting planning permission, we're in Regulation 9, sub 3 on the next page. In exercising any functions, they must have regard to the requirements of the directive. Harris construed that and held that when one's having regard to requirements and one is the only body responsible for fulfilling those requirements, that's a strong obligation actually to achieve them. It's more than the usual have regard to policy. You don't need to get into whether that was right or wrong, but my point is simply that on the face of the legislation, Parliament has intended outcomes reflecting the directive. Then my fifth point is the one I've already made when we looked at Barker. This case is different to the 1988 EIA regulations because there is a basis in the habitats regulations to require subsequent stage appropriate assessment, i.e. Regulation 63 read if necessary with Regulation 9. Otherwise, the substantive obligation has been fully transposed.
Sorry, there is a basis in the habitats regulations. How did you push it exactly?
To require subsequent stage appropriate assessment. My sixth point concerns Regulation 63 sub 6 that the appellant placed some reliance on. It's page 34 within tab 5. This is the provision that says, in the light of the conclusions of the assessment and subject to IROPI, the competent authority may agree the plan or project only after having ascertained it will not adversely affect the integrity of the site. That is not saying that the conditions are separate from the consent or anything of that kind. All Regulation 63.6 does is say that in judging whether there's a risk of harm, the competent authority should consider the effect of the project that is being authorised, i.e. the development as controlled by all the conditions and obligations that secure mitigation. One assesses what actually will happen in practice, what is allowed. That's all that provision does. And the rejection of the UK's argument in Barker shows that the outline permission is not the consent without agreement to the implementing decision. Seventhly, responding to another of the appellant's points, Regulation 86, which is on page 81, says that Chapter 2 should be construed as one with the Town and Country Planning Act 1990.
Sorry, you're going a little too fast for me. That's
sorry,
my
no.
fault, not yours at all. Sorry, the point you're making first of all.
It's the rebutting the appellant's point that Regulation 86 assists their case. That's the provision that says construe the habitats regulations as one with the Town and Country Planning Act.
Yeah.
And my submission is that when one looks at what the Town and Country Planning Act does, section 72(1)(a) allows a condition to be imposed for regulating development, but that doesn't mean that the conditions aren't part of the overall authorisation. We saw from Whitley, compliance with the condition is required in order for the development to be authorised. So in my submission, the case I'm advancing is of a piece with the position under the Town and Country Planning Act. And then finally, my 8th submission on contra legem is that a strict interpretation would produce a result at odds with the underlying purpose of the legislation, i.e. substantive protection for internationally important habitats and species on a strict precautionary basis. And it would mean the competent authority here would be compelled to agree a project that has not been assessed, and if it were to be assessed, would fail the assessment. And in my submission, submissions of contra legem must be treated with considerable caution when the interpretation being urged on the court would create a lacuna contrary to the very purpose of the legislation. So for that combination of reasons, in my submission, an ordinary domestic purpose of interpretation or an interpretation via the medium of sections 2 and 6 of the Withdrawal Act leads to the conclusion that appropriate assessment can be required at the subsequent consent stage.
Mr. Balls, can I just ask you to help with this? Conceptually, the submission you just made that a purposive construction is called for, is that on your submission different from what's usually called the Marleasing principle?
It is, in the sense that Marleasing is a stronger purposive interpretation. One has ordinary domestic principles. Marleasing is effectively a sort of super-added purposive interpretation. In my submission, I get home on an ordinary domestic interpretation, but if I needed more, the Marleasing approach retained via sections 2 and 6 would get me there.
Thank you.
Then very quickly before I turn to ground 2, I just need to deal with noble. And in my submission, the appellant's reliance on noble and formal validity is misplaced. It presupposes that the directive and the regulations allow a front-loaded once and for all consideration of habitats issues, and that the agreement is given at that planning permission stage. But as we've seen, that's inconsistent with the Court of Justice reasoning in Barker. It's inconsistent with Mrs. Justice Lang's conclusion in Wingfield that there's no agreement until the implementing decision has been approved. And the reference in Noble to giving an earlier decision to grant outline permission all the effects of a valid decision doesn't mean treating that decision as fully having discharged once and for all the Article 6.3 obligation.
I'm sorry to interrupt you. This may be important because on the face of it, Noble is binding on this court.
It is, my lord, yes.
So is it your submission that it has been implicitly overruled by Barker?
It's not, my lord, no. My submission is that Barker effectively analyses the consent as a series of measures which in combination need to be attained before the project is authorised, and where one is dealing with a circumstance where the final piece of the jigsaw hasn't been obtained, one is not, going back to my answer to my lord earlier, one is not second-guessing, questioning, revoking any of the pieces of the jigsaw that have been put in place. Noble applies to all of that part of the equation. It's the...
That's what I thought, and that's very helpful. That's really the answer you gave me earlier this morning. I only ask you the question because I think yesterday Lord Banner submitted that you had submitted, I think below, that Noble has been overruled, even though it wasn't referred to.
No, that was no part of my submissions below. I think it was said against me that that must be the consequence of my submissions, but no, my submission is that the two can be reconciled, and Wingfield shows Mrs. Justice Lang thought that that's exactly what she was doing in that case.
Thank you very much.
So that is my response to ground one. Ground three, I think I've effectively dealt with in the course of my submissions, but just to draw everything together, very briefly, Article 6.3, which I don't think we need to turn up, the obligation is to assess the plan and project and expressly its implications for the site. So it's the implications of the plan or project that Article 6.3 requires to be assessed. And the question is whether it, i.e. the plan or project, will not adversely affect the integrity. On the face of the directive, ground three is incorrect. The same language appears in Regulation 63. Unsurprisingly, one must make an appropriate assessment of the implications of the plan or project, not of the RM or the condition discharge application, but the whole thing.
And that's consistent with the EIA directive and regulation.
Exactly, my lord. And just for your note, I've taken the court to these passages already, but it was Barker in the Court of Justice, tab 14, paragraph 48. It was Barker in the House of Lords, tab 15, paragraph 24. And then Friends of the Irish Environment, tab 27, paragraph 52. So taking the legislation and the case law together, in my submission, that's a complete answer. That leaves me with ground two then, the relevance of the impact of the Ramsar site on the inspector's decision. In my submission, the key question of law here is how does the court decide what is relevant to the discharge of a pre-commencement condition? And as in all areas of public law, what is relevant when exercising a statutory discretion is a question of statutory construction. And there are three broad possibilities. Firstly, the statute expressly or impliedly requires something to be considered, like section 70 sub 2a requires consideration of the development plan, or in another context, section 149 of the Equality Act requires due regard to be given to various protected characteristics. So that's the first scenario, express requirement to consider. Second scenario, which the appellant says we're in, is the statute expressly or impliedly prohibits something from being considered. Then the third category, which in my submission we're in, the statute expressly or impliedly allows the decision maker to have regard to something if in his judgment and discretion he thinks it's right to do so, subject to public law controls governing the exercise of that discretion. And there's
Why on your submission is this not a Category 1 case? If you're right that it's a Category 3 case, then different local authorities around the country might achieve different outcomes, and it might be said that's detrimental to the habitats.
I was going to come on to, there's a caveat to add to 3, which is there are some considerations which, although discretionary relevant considerations, are so obviously material as to be mandatory. And in my submission, given what national policy says about Ramsar sites, the effect on the Ramsar is so obviously material as to be a mandatory consideration. So I say it is mandatory, but through the vehicle of that third category with the with that category. I mean, I think it makes frankly no odds to my argument which pathway one goes into it, but my submission is it is a mandatory relevant consideration.
But as I understand it, what you're saying is it's mandatory not because statute expressly or impliedly requires it, but because it would be irrational to ignore it. Is that right?
In my submission, stepping back, one has section 70 requiring consideration of development plan and other material considerations. And we know from Wright that other material considerations is a broad concept, but subject to the Newbury criteria, must be a proper planning purpose, must relate to the use and development of land and the particular development in issue. At the other end of the process, one has the enforcement provisions in section 172. We've got copies we can hand up if necessary, but there, in deciding whether to take enforcement action, the local authority is told to have regard to the development plan and other material considerations in judging whether it's expedient to enforce. So my overarching submission is why, sandwiched in between that, should the discharge of pre-commencement conditions or reserve matters, why should Parliament impliedly have narrowed the scope of matters that are material? And in my submission, there's no basis for implying that the category is narrower, but then one comes to the question of rationality when exercising the discretion to discharge a pre-commencement condition. Is it rational on the facts of the case to grant or refuse the application, having regard to something which qualifies as a material planning consideration? On the facts of this case, yes, given the nature of the impact, the status of the site, the provisions of the Wildlife and Countryside Act, which expressly require planning authorities to be notified of designation, that makes it rational to refuse reserve matters approval or to discharge a condition.
All right, I'm still struggling with this aspect of the case because Lord Banner's submission was that this is a jurisdictional question and it's not a question of a rationality test. And I'm not clear from your answer whether you're taking issue with Lord Banner's analysis or not.
I am taking issue with his analysis. In my submission, what is relevant to the discharge of a condition is expressly or impliedly determined by the Act, and in a context where other material considerations are expressly brought into play.
I appreciate, I'm obviously being very simplistic here, and I'm sure the fault is mine, not nobody else's, but why is not the correct approach to say what the Act says is it's got to be a material consideration?
Yes.
And that allows for discretion and judgment on the part of decision makers as to what is material, subject, as you say, to public law control. And the key question, therefore, is it rational to say that something is a material consideration or not? And I can understand a submission that says that where the national framework says you treat Ramsar sites in the same way as European sites, it would be irrational for the decision maker to treat that as an immaterial consideration. If that was the shape of the argument, I would understand it, at least in terms of its conceptual framework, whether or not it's right. But you seemed, in answer to my earlier question, to be putting it a different way, and I'm not quite sure how that does differ.
I think the way I put it is, when discharging a pre-commencement condition, what is relevant is determined expressly or impliedly by the Act. Impliedly, it is other material considerations given the context of Section 70 and Section 172. Then in actually exercising the discretion to discharge the condition, it's a question of rationality. Is it rational on the facts of the case to have regard to and to place weight on that what is only a potentially relevant consideration? It's the exercise of the discretion that the rationality bites on, not whether something is in fact relevant, because relevancy is a question of statutory construction. It's not for the decision maker to decide in their judgment what is or isn't relevant. It's in there where one has a range of potentially relevant considerations that may or may not be taken into account, and one only errs if it's a material, or so obviously material consideration that it is rational to leave it out of account. The decision maker effectively has a a la carte menu to choose from, and if they on the facts of a case irrationally or rationally leave something in or out of account, that's where the control is. So my submission is that to decide what is relevant, one construes the statute, and there is no narrower category than other material planning considerations. But then in exercising the particular discretion on the application, one is asking, is it rational to actually have regard to that particular thing on the facts of this case and place the weight that you have done on it? That's the safety valve. So in my submission, it is a case about rationality, but as a matter of public law principle, what is relevant is a question of construction, but then how that is then used in exercising the discretion is a question of rationality.
Well, expressed in that way, I understand what you're saying. But when you say relevance is a question of statutory construction, that makes perfectly good sense. But which is the statute we are construing? Because at the moment, I don't see why the answer to that question isn't the Town and Country Planning Act.
It is, my lord. It is. So my submission is Section 72 is the power to impose conditions. So the statute expressly recognises that power. There is no statutory provision dealing with the discharge of pre-commencement conditions. So in determining what is, there's certainly nothing express as to what's relevant or irrelevant to that exercise. It's a matter of implication in light of the whole statutory scheme. And my submission is the correct implication is, given the terms of Section 70, the broad definition of material considerations that are relevant to the grant of planning permission, and given the terms of Section 172 1A, other material considerations also come into play at the enforcement stage.
I found this debate helpful, but I would find it even more helpful if you could now take us to those provisions in the Act, just to solidify that submission.
Certainly, my lord. So we have Section 72. I think that might be in the documents.
Yes, it is. Tab 2.
I'm grateful, my lord. So it's expressed to be without prejudice to the generality of Section 70, subsection 1. So that's the power on an application to grant planning permission either unconditionally or subject to conditions. So there's the general power, and that's at tab 2, page 4 of the main authorities. Section 71A, power to grant conditional planning permission. Section 72, without prejudice to that, the generality of that, conditions can then be imposed for a number of specific purposes, including regulating the development. In exercising the Section 70 discretion to grant permission unconditionally or conditionally, the statute expressly says at 72C on page 5 of the main authorities
Sorry, where are we now?
Sorry, main authorities, tab 2, page 5.
So this is section 70, subsection 2.
That's correct. Subsection 2C, authority shall have regard to any other material considerations.
Yeah.
So at the front end of the process, what is relevant is any other material considerations, which we know from right is construed in the Newbury sense with the limitations inherent in that. I referred to enforcement at the back end of that process. If I could hand up the relevant provisions, please. So in the clip, the second page is section 171A. I just highlight subsection 1.
Just a second. 171A. I think the first thing actually to do with this, if you don't mind, is just put it in the clip. It's not going to be a laborious thing to do. Be in at tab 7, won't it?
Tab 7, that's right.
Let's just do that. I know it's slightly fussy, but there we are. Right, so I put that in it. All of those materials have now gone in it.
I'm grateful, thank you. So second page of the clip, just to note, section 171, capital A1 is the point I was making earlier about the use of the concept of breach of planning control rather than authorisation in the...
Sorry, I said 8, I meant 7. Sorry. 171A.
171, capital A, subsection 1, that's the point about the concept of breach of planning control being the statutory term which we saw in Whitley. If there's breach of planning control, it's not authorised.
Yeah.
And then the relevant point I wanted to make here is the penultimate page of the clip, section 172, dealing with issue of enforcement notices. So 172, power to issue a notice, enforcement notice, where there's been a breach of planning control as defined, and the local authority considers it expedient, and in making that judgment, it has to have regard to the provisions of the development plan and other material considerations. So the same rubric as we saw in section 70. So my submission is that the exercise of discharging a pre-commencement condition is a statutory function that isn't expressly dealt with in the Town and Country Planning Act, but it sits in that context where both at the decision whether to grant the permission and whether to enforce against the unauthorised development, Parliament has expressly said other material considerations as construed in right are relevant.
So I mean, sorry, I'm being perhaps rather slow, but how it would go then would be this, that if there were a pre-commencement condition and that hadn't been discharged, there could be enforcement action.
There could, my lord.
Because that would constitute a breach of planning control.
It would. And to pick up my lord's point from yesterday, the Whitley principle would apply such that any of the development would be unauthorised, irrespective of the content of the pre-commencement condition that was breached. So if I have a mixed-use scheme, there's a pre-commencement condition requiring the approval of details in relation to the commercial units, and I start building the residential units. My residential units are unauthorised.
And the species of breach of planning control would be a 171A 1B breach, i.e. failing to comply with any condition.
It would, my lord, yes.
And that's the route.
That's right. And then in deciding whether to enforce against that breach occasioned in breaching the pre-commencement condition, the local planning authority is expressly told it can consider other material considerations, which would include, even on the appellant's case here, the impact on the Ramsar site, because the appellant accepts that's a material planning consideration in the Section 70 sense, because the process on its case should be front-loaded and considered at that stage. A fortiori, it's a material consideration at the enforcement end of the telescope as well. And it would be an odd result to conclude that Parliament didn't intend material considerations to carry the same meaning.
Mr. Wills, I may be wrong. I did not understand Lord Banner to be making the submission that material consideration should be ignored in the present context. I think what he was submitting was that what you've been submitting is a material consideration, is not, as a matter of law, a material consideration, because the only thing which remains material by this late stage of the decision-making process is circumscribed by the terms of the conditions themselves.
He submitted positively, as I understood him, that this was an immaterial consideration. Whether there's any space, let's go there, but whether there's any space between that which is not a material consideration and that which is an immaterial consideration is not for this case.
Indeed, as I understood his submission, the effect on the Ramsar would be material at the outline permission stage, but by the time one gets to the discharge of conditions, it is not, because of some implied principle that the conditions themselves define what is relevant, and the only authority for that is Medina, which I'll take the court to, and in my submission it doesn't establish that. My submission is that what is material is the same as is material at Section 70 or at Section 172. The real question is, in exercising the discretion to discharge the condition, is it rational to actually place weight on and refuse or grant on the basis of that potentially relevant consideration? So that's my submission. That
Mr. Wills, can I ask you, and this is a very, very basic question, so forgive me. I think you've said that the actual decision that we're dealing with in the present appeal is not expressly governed by any legislation.
I think there's a development procedure order dealing with the form of applications, etc. But the actual concept of making an application to discharge a pre-commencement condition, there is no express provision in the Act that it's implicit that such a procedure must exist, because it's clear that conditions can be granted, can be imposed through Section 70 and 72.
I was just going to ask you a simple procedural question. How then does the right of appeal to the Secretary of State get generated? There must be some legislative provision somewhere, which says that
Section 78.
Yeah, so it is a relevant, whatever the local authority decided in the present case was a relevant decision, which then generates an appeal.
It was. So the Act recognises that this is a species of planning decision makers will make. What it doesn't do is, in the way that Section 70 and 172 do, is set out in terms what is.
Yeah, there's a linguistic point here which has been puzzling me, and I think what's just been said may explain it, which is the jargon seems to be to refer to discharge of conditions, whereas actually what's going on, I think, is a determination that the conditions have been complied with, or sufficiently complied with.
Yes.
Or not it, right.
That's correct. Yes, indeed, my lord. Because usually the condition will be drafted, such and such has to be submitted for approval.
And so what happens is the developer says, by doing X, I have complied with condition Y. And in our case, the local planning authority has said, no, it doesn't. And that is then an appealable decision.
That's right, my lord, yes.
Yeah.
You've said, I think, that the procedure is provided for in the Town and Country Planning General
Development Management Procedure.
Development Management Procedure Order. Is that right? 1995, as amended.
Yes.
Do we have those provisions?
We will get them for you.
I mean, I think we do need just to assemble that, because what I was going to do actually was to look at the decision letter itself to see whether the inspector whether the decision is recorded anywhere.
It's page 73 of the supplementary bundle. So in the first bullet point, it is an appeal under section 78.
Sorry, 73.
73.
Yeah, but he doesn't reveal the statutory foundation for that. The legislative foundation, I should perhaps say.
No, if the court is content, the parties can seek to provide those relevant documents in an agreed form before the end of today, if that's what it is.
Because I think my Lord's question is important in this procedure, actually.
So I was going to go to Medina to see if that does provide any support for the position that relevancy is narrowed at this stage. Medina is tab 10 of the bundle. And the court can see from the head note that the claimant owned 105 acres of land joined to the highway by a lane which it owned. The local authority refused an application to renew a lapsed full planning permission, and so the claimant appealed. The Secretary of State granted outline planning permission because he was concerned about access and imposed a condition that details of the means of access had to be submitted for approval. The local authority didn't determine an application for approval, and so there was an appeal to the Secretary of State, and the reason they didn't determine the application was because they were clear that they would only accept an access not in the claimant's ownership. The inspector dismissed the appeal because access on the claimant's land was unsatisfactory, and we see just before the holding, Sir Frank Layfield allowed the statutory challenge and held that the condition was only intended to secure the best access on the claimant's land, not to require third-party land to be used. The Court of Appeal dismissed the local authority's appeal and held that the condition didn't require work on third-party land. Within the judgment of Lord Justice Glidewell, if I could ask the court to go to page 118, please. At the very foot of the page. It was common ground that a condition couldn't be imposed on a planning permission requiring work to be carried out on third-party land.
Sorry, 119?
Sorry, 118, very foot of 118.
Yeah, sorry. Yeah, sorry.
So can't condition something to require work on third-party land. At the foot of 119, Lord Justice Glidewell notes that the condition such as that under consideration here, which is a normal condition on an outline planning permission, does not in form require any particular work to be done within or without the site. What it does is, what then he asks are the limits placed on the outline permission on the authority's power to approve or disapprove the details that are submitted. So essentially the question that we're being asked in this case, what are the limits of the discretion? The nearest expression of authority he finds is Lord Morris's speech in Kingsway. And if I could ask the court to read the quotation and then the remainder of Lord Justice Glidewell's paragraph.
Down to patently as unlawful.
That's correct, my lord, yes, thank you. So in that passage, Lord Justice Glidewell is not holding that the limits on the discretion are found in the words of the condition. The limits on the discretion to grant or refuse the application are public law controls, that the decision mustn't be a misuse of power or irrational. But that was the ratio of Medina. On the facts, it was irrational or a misuse of power to refuse for the reasons the authority gave. The passage that my learned friend relied on the next page was dealing with a different point. We see first main paragraph, Mr. Porton made another submission. He argued that the condition can and should be construed as a negative Grampian style condition, not requiring works on another site, but no development shall proceed until an access is found. That
it wasn't a positive requirement to put the access on somebody else's land. It was simply a negative requirement that you can't get your development until you've provided an access.
Exactly, my lord. And so where Lord Justice Glidewell then in the next paragraph says, I look back at the wording of the condition itself, what he was dealing with was that submission that the condition should be construed as a negative Grampian one. He's not referring to the wording of the condition to look at the ambit of the power to approve or disapprove the details. He's dealt with that on the previous page through the prism of the concepts of misuse of power and rationality. So Medina is not authority for the proposition that relevancy at the discharge of condition stage is cut down by the words of the conditions themselves. And then I fall back to my other submission. If there is no express cutting down, in my submission, no implied cutting down, and no authority to support a cutting down, one is left with the implication that what is potentially material carries the same meaning as in Section 70 or Section 172. It's the broad run of material planning considerations. And then the question is, in exercising the discretion to grant or refuse the application, is it rational in public law terms to do so having regard to that consideration?
Insofar as Lord Banner's submission yesterday was based on the concept of jurisdiction, I think your submission is that's the wrong analysis. The jurisdiction exists, you submit.
Yes.
But of course it must be exercised lawfully according to well-known principles of administrative law.
Exactly.
One of which is that you cannot use your power, you cannot misuse your power. That's what Lord Justice Glidewell was saying was going on in that case.
That's correct, my lord.
That's the only proposition for which Medina is authority, you say?
I'd say, my lord, yes. And what makes this not a misuse of power is we have Section 37A of the Wildlife and Countryside Act. If I might just turn that up, I've not looked at it yet. It's the first tab of the authorities bundle. First page. So this is Section 37A of the Wildlife and Countryside Act 1981, dealing specifically with Ramsar sites. It provides in subsection 1 that when a wetland is designated under the Ramsar Convention, the Secretary of State is under a duty to notify Natural England. And then in subsection 2, subject to certain exceptions which deal with devolved authorities and we don't need to worry about, upon receipt of that notification, Natural England and the other statutory conservation bodies in the devolved jurisdictions shall in turn notify the local planning authority in whose area the wetland is situated. And so it's clear we're not in the territory here of just an unincorporated international law obligation. Parliament has expressly legislated for designation to be notified, and particularly pertinently notified to planning decision makers. And the irresistible implication in my submission is that Parliament intended effects on Ramsar to be taken account of in planning decision making. So that's one aspect of why it's reasonable. The other aspect is because we have prospectively promulgated national policy in the form of paragraph 181, telling applicants for planning permission that Ramsar sites will, as a matter of policy, be given equivalent protection to habitat sites. And in my submission, 181 is not seeking to make Ramsar sites relevant. They are material planning considerations. They're relevant just as a matter of statutory construction. What 181 is doing is telling decision makers on the merits how they should treat them. And the direction, if you perhaps turn up 181, it's the final tab of the main authorities, tab 34. It says that the following should be given the same protection as habitat sites. 181B, listed or proposed Ramsar sites. So it's a direction as a matter of policy as to how to treat a relevant consideration, which goes to the weight and the rationality of actually then including that as a factor in the discretion to discharge the condition. So in my submission, it's wrong to characterise 181 as being the thing that makes the Ramsar site relevant. We're in the territory in 181 of the concept that Lord Sales talked about in Wright, national policy giving a direction as to how the merits should be treated, rather than trying to expand the concept of relevant considerations. I don't know if it would assist the court briefly to go to that passage in Wright. So Wright can be found tab 24. And it's page 417, beginning at paragraph 50. So as the court will recall, the appellant was arguing that the concept of material considerations is a living instrument and capable of being expanded according to the terms of national policy. And then Mr. Kingston, for the appellant, sought to gain support for that argument from a series of cases in which policy was relied on in order to justify the imposition of conditions, or as he submitted, to identify material considerations for the purposes of the planning statutes. And Lord Sales says on proper analysis, those authorities don't help. He refers firstly to Copeland in the High Court, where permission for a fast food outlet near a school was refused, having regard to government policy on healthy eating. It was conceded in that case, we see just between F and G, that was material. Lord Sales regards that as a correct concession. Whether or not the property was used as a fast food outlet was very directly a matter concerning its use. The policy did not affect that one way or the other. It was relevant to a different question, namely whether in policy terms the grant of planning permission would be justified or not. And then in 52, Lord Sales notes that the same analysis applies in relation to all the other authorities relied on in each case. Condition was imposed or permission was refused on the basis of a consideration directly relating to the use of land, so falling within Newbury, and the policy justification for the condition or for treating the considerations having weight was a distinct matter. So contrary to the submission in the last sentence, the policy guidance didn't affect the meaning of the term material consideration in the planning statutes. So here I say, it's a matter of construing material considerations in section 70, which in my submission is the correct aspects of the relevancy for discharging a condition. Effect on the Ramsar is material. It clearly affects, it's about the use and development of land. It's an effect caused by this particular proposal, so it doesn't fall into the ELSIC territory of being a tax or buying and selling of a planning permission. Reinforced by section 37A, so on its own terms, effect on the Ramsar is a material consideration. Paragraph 181 is just like those policies in Copeland, etc., telling decision makers on the merits what to do about it. Para 181 could say, give great weight to Ramsars. The outcome of this case may be very different if that's what the policy direction was, but the policy direction is to afford them the same protection, i.e. apply a strict precautionary approach and only grant an implementing consent, which is the very discretion that the decision maker is exercising here, if satisfied to a standard of certainty that there will be no adverse effect. So in my submission, Wright supports my case. Elsick doesn't detract from it. Elsick was a case where the consideration in issue fell outside the statutory definition of material considerations because it offended the rule against buying and selling a planning permission. The contribution sought was nothing to do with the effects of the development, and so it was not a proper planning purpose to require it.
Yes. Lord Sales dealt with Elsick, which he called Aberdeen earlier in his judgment, and he doesn't confine it. Also, Lord Banner submitted yesterday that last point you just made. So he does quote Lord Hodge in his paragraph 42, page 415. And that is the contribution of money point.
Yes.
But then Lord Sales at paragraph 43, so Lord Banner submits, says that the principle is a wider one than that. Now, what do you say in response to that?
In my submission, it is a wider point. As a matter of fundamental constitutional principle, if what is relevant is a matter of statutory construction, if it's not there expressly or impliedly, it's not there. One cannot, through policy, then introduce it. My submission is we're not in that territory here at all, because the effect on the Ramsar is a material planning consideration applying the Newbury criteria, and 181 is not trying to make material something that isn't material. It is taking a material consideration and giving a direction as to what decision makers should do with it.
Thank you.
No, I certainly don't gainsay what Lord Sales said. It is undoubtedly correct. I think I can finish ground 2 very shortly. I've just 3 very short points to make. Firstly, when one reads the decision letter, the inspector clearly did consider the reasonableness of refusing to exercise his discretion to grant the consent. He looked, it's page 79 of the supplementary bundle through to page 80. Examining whether refusing would be to reopen issues that were settled by the outline permission or the discharge of condition 7. That's just to take up the decision letter very, very briefly. 79. He runs through all the principles which in my submission remain good law and concluded that none of them were offended. So at the top of 79, we've got paragraph 30, where he deals with Cranston and Proveron, which is the Medina case. As a matter of judgment in 31, he concludes that mitigating the effect on the Ramsar wouldn't affect how the operational development is carried out, because in 32, it's going to be off-site mitigation that is the solution. He looks at condition 7 then in paragraph 33 and goes on to conclude in the run of paragraphs up to 36 that the validity of the outline permission or the discharge of condition 7 aren't under threat because it's not requiring something different to be done compared to what's been approved. So it's not a misuse of power in that sense. And 38 over the page, while the validity of the planning permission is not in question, neither can its present status be rightly regarded as implementable, as there is a need to satisfy the conditions prior to implementation. And in my submission, that chimes with the Court of Justice in Barker. The development is not entirely authorised. So the inspector has carefully looked at the facts to make sure he's not offending any of the established principles. And it was not unreasonable, therefore, for him to refuse to approve the discharge of the pre-commencement conditions. Just for final completeness, page 85, paragraph 72 through to 77, the inspector, in my submission, adopts the correct approach because, of course, Ramsar sites don't benefit from legal protection. They only have policy protection. So the inspector recognises that one can't simply apply paragraph 181 and say, I must therefore refuse. That would be to fetter his discretion. But what he does in 72 through to 77 is consider all the countervailing factors. So the 73, he notes the delay to the delivery of phase 3 and the wider development. 74, he notes the national and local housing need. 75 notes that we're dealing here with a risk of harm to the Ramsar rather than an allegation of direct harm. But even taking all of that into account, he still concludes that the appeal should be refused because of the weight he attaches to the protection of the Ramsar. So it's not my submission, but 181 mandates refusal in the way that Regulation 63 does. It cannot. It is only a policy, and it would be a fetter on discretion to apply that rigidly. But the inspector's decision letter in my submission is impeccable because that's not what he does. So to the extent the court has before it evidence of the consequences of the conclusions reached by the judge below, they are matters that this inspector considered in exercising his discretion, and there is no rationality challenge to his judgment. Unless I can assist the court further, those are my submissions.
Sure. Thank you very much, Mr. Ross. Thank you. Yes, Mr. Wilcox.
My Lord, thank you. I begin by gratefully adopting the submissions of my learned friend, Mr. Moores. I won't repeat them, my Lord. You have them. You also have my skeleton argument, and I don't propose to repeat anything in that either. What I do propose to do, my Lord, is three things which I hope will assist. First, I'm going to attempt to step back from some of the detail of the authorities and extract the relevant propositions on which my case, and I understand Mr. Moore's case as well, to turn. Secondly, there are a handful of residual points emerging in the case on which I'd like to address the court. And thirdly, my Lord, I'll deal, for I think will be for the first time in the appeal, with the submissions of the interveners.
Right.
I'll do that very briefly, my Lord. I anticipate I'll be no more than 15 or 20 minutes.
All right.
Beginning then, my Lord, with the propositions which emerge from the authorities. Insofar as they relate to the Habitats Directive, my Lord, I say that there are 6 key propositions which emerge. Those, my Lord, are as follows. 1, the Habitats Directive is focused on outcomes, not on processes. If authority is needed for that, it's found in Wingfield at paragraph 72, and the case is cited therein. 2, the outcome which the Habitats Directive requires is to avoid any risk of harm to the integrity of protected sites. Authority for that is Valenzy, paragraph 67.
67.
67, my Lord, yes, of Valenzy.
Okay.
3, the mechanism by which that outcome is secured is to prohibit the agreement of a project unless and until that project has passed its appropriate assessment. That is also confirmed in Vadensee, paragraph 67. Four, the concept of agreement in this context means the implementing act. In other words, the final stage in the process by which otherwise unlawful development becomes lawful. For that, we have Friends of the Irish Environment, paragraphs 42 to 47, which we saw this morning. And we have Walloney, paragraphs 142 to 143.
Yep.
5, the appropriate assessment itself is to be comprehensive and up to date, without lacunae. We get that from Friends of the Irish Environment, paragraphs 54 to 56. And 6th and finally, all of the above is to be approached on a strict precautionary basis to ensure a high level of protection. That comes from People Over Wind at paragraph 30 and Friends of the Irish Environment at paragraph 51.
You said a strict precautionary basis to
ensure a high level of protection, my lord.
Okay.
It's worth bearing in mind, my lord, on the facts of this case, the appropriate assessment, as Mr. Moules explained, came about because of a material change of circumstances in 2020. That is after the conditional reserve matters approval. And it's also worth bearing in mind that there is no dispute in this case that if an appropriate assessment is to be carried out, that assessment will be failed. In other words, if this development is allowed to proceed, there will be the risk of a harm to a protected site. And it follows, my lord, that the appellant is seeking the very outcome that the habitats regime and the Ramsar regime by adoption is designed to prevent. That, my lord, in my submission, plainly bears on the exercise of purposive construction, which my learned friend Mr. Moules has taken the court through already, and which I don't repeat. Turning then, my lord, to the residual points I'd like to pick up. The first of them relates to the relationship between Noble and Barker, and I have in mind in particular, my lord, Lord Justice Singh's questions to my learned friend this morning. There are a couple of paragraphs in Barker which the court hasn't seen yet and which might assist on how they, what I think my Lord Banner would have said was a tension between Barker and Noble is in fact nothing of the sort. If we can take up, please, Barker in the House of Lords, which is at tab 15 of the authorities bundle. And I'd like to turn to page 243, please. And what we find at 243, beginning at paragraph 27, is how the court resolved the appeal in terms of the orders which it made. The first thing to note is that what was sought by the claimant here in paragraph 27, advanced by Mr. McCracken, was a declaration that the refusal to consider EIA at reserve matters was unlawful. The reason he sought a declaration, he tells us, is because the planning permission had expired through a fluxion of time, so he could no longer seek an order. the order.
Grateful that you've drawn that to our attention, because I was a bit mystified by why that wasn't what they were asking for. So now I understand. Thank you.
I'm glad to be of assistance, my lord, and it's worth noting the order which he was seeking was a quashing of the reserved matters approval, not the outline. The relevance of that will become apparent in just a moment, my lord. Lord Hope, in paragraph 28, identifies the meaning of development consent as embracing both the outline and the reserved matters stage, as Mr. Mools has explained. And then we get this at paragraph 29, which is the important passage. Lord Hope begins by noting that it is no longer possible to challenge the grant of outline planning permission on the ground that an EIA was required at the outline stage. So Lord Hope recognises at the very outset of this paragraph that the outline was safe from challenge. In my submission, that is an implicit acknowledgement of the validity principle in respect of the outline permission on these facts. He goes on then to note that the quashing of the reserved matters is academic because of the effluxion of time. And then he tells us, but the appellant is entitled to the declaration that the advice that the officials gave to the committee that an EIA could not, as a matter of law, be required at the stage of approving the reserved matters was wrong. He notes that Mr. Justice Sullivan's observation in Chew that if significant adverse impacts on the environment are identified at the reserved matters stage, and it is then realised that mitigation measures will be inadequate, the local planning authority is powerless to prevent the development from proceeding, must now be regarded as unsound. And he concludes by saying if it's likely there will be significant effects on the environment which have not previously been identified, an EIA must be carried out at the reserved matter stage before consent is given for the development. So, my lord, it's not a case where what Lord Hope thought he was doing here involved any limiting or cutting down of the principle of validity. He recognises the principle of validity by noting that the outline is safe from challenge. But that does not prevent further layers of assessment being required at the reserved matter stage. And the reason for that is, as Mr. Mools submitted, it's because the outline assessment is a piece of the jigsaw. It's not the whole of the jigsaw. And it is possible for the whole picture to be legally deficient without any deficiency occurring at the earlier stage. That's what happened in Barker. And as my learned friend Mr. Mools has taken the court through already, the same outcome will occur in the habitats context and occurs in this case. It involves no attack on the decisions at outline stage or conditional reserved matters approval in this case for the council and the inspector to have done what they did in refusing to discharge the conditions. So, my lord, that's the first of the 2 points I want to pick up that are outstanding according to my note. The second point relates to ground 2, my lord. Now, Mr. Mools has made submissions which I fully endorse and adopt as to why Lord Banner was wrong to suggest that relevancy is cut down when one's dealing with the discharge of conditions. I'm going to submit, my lord, that even if Lord Banner is right and relevancy is confined to the 4 corners of the condition, the inspector and Sir Ross Cranston were nevertheless correct in their approach. The basis, my lord, of that submission is as follows. In deciding the relevancy of a policy to a decision, there are 2 questions to be asked on Lord Banner's analysis. Question 1, what is the thing that the policy seeks to regulate? And question 2, is that thing at issue? Is that thing live in the decision? Beginning then with question 1, what is the thing that MPPF paragraph 181 seeks to regulate? And the answer, my lord, is it seeks to regulate the authorisation of development. And that's because paragraph 181 brings into policy the approach of the habitats regulations. And we've heard already that the habitats regulations are specifically concerned with the implementing stage, with the point at which unlawful development becomes lawful. Question 2, is the authorisation of the development something which will happen as a result of the decision to discharge these conditions? The answer is yes, it is. Because as my lord, the senior president noted in argument yesterday, the thing that all of the pre-commencement conditions have in common, irrespective of their subject matter, is that they represent a bar on lawful development unless and until they are discharged. And it's common ground that they are pre-commencement conditions which, in the Whitley sense, will result in the whole of phase 3 being unlawful if it's commenced without their discharge.
It's my fault. I'm not following this at all, I'm afraid. This is all predicated on the assumption that Lord Banner is correct.
It is, my lord, yes, that's right.
That the relevance question is confined by the four corners of the conditions.
That's right, my lord.
Well, his basic submission, very simple, that this is water that has flowed under the bridge by now, and it's far too late to be saying at the stage where the only issue is have the conditions been complied with. The local authority, he says, can't revisit questions it's already signed off on at an earlier stage.
Well, my lord, in my submission, that's a mischaracterisation of what the conditions are doing, because the conditions are also preventing lawful implementation. They are pre-commencement conditions, and the effect of the discharge is not just to approve the content, it's also to release the whole of the development.
Well, I understand that, but at the moment I'm not understanding why this is analytically any different from Mr. Mooles's argument. In other words, why this works if you concede that Lord Banner is correct, that the four corners of the conditions do in fact constrain what can be relevant.
Well, my lord, it may be that these submissions simply further amplify why my learned friend Mr. Mooles is correct, but the point I was seeking to make, my lord, is that if one is looking for as it were, a subject matter nexus between the condition and the policy, that is found in the fact that one of the things that is within the four corners of the condition is the release of the whole of the development to become
Well, that would apply to any condition, any pre-commencement condition.
Quite so, my lord, quite so.
But Lord Banner's very simple point is, look, if what you have is a condition concerned with surface water and not to do with flood water, for example, you can't then, when purporting to say, well, we're not going to discharge the condition about surface water, have regard to something which is to do with something else. That's what, I mean, he may be wrong about that, but the reason he's wrong about that is for reasons we've already heard. I'm not sure he's also wrong about it for this reason. That's
well, Lord, if the alternative formulation doesn't assist, as I say, it may be that the alternative formulation is simply grist to Mr. Mooles's mill, as it were, and confirms why he's right in his approach. My lord, I simply presented the argument as another way of looking at it in the event that Mr. Banner's four corners argument is the one that's preferred by the court. My primary submission is that the court shouldn't prefer the four corners argument and should adopt what's said by Mr. Mooles. Finally then, my lords, I'll turn to the intervener's position. And I'll do this very briefly for reasons which will, I hope, become apparent. The intervener's submissions, my lords, are in two sections. They do two things. The first thing that the interveners do is draw attention to what they say are the very important policy considerations around the need for more housing in England and Wales. The second thing they do is invite the court to say what the answer to this case would have been had the decision occurred now, effectively, had it occurred post the changes in Withdrawal Act law which occurred last year. I'll take those two sections in turn, my lord. Beginning with the policy points which are made as to the need for housing. My lord, it's not in dispute, I think, that there is a policy imperative for more housing in this country. But there is another policy imperative at play here, which is the protection of environmental sites in unfavourable conditions, like the Somerset Moors, Ramsar. As Sir Ross Cranston noted below, the resolution of those imperatives, the decision as to which is more important in any given case and the balance between them, is a matter for others. It is not a judicial function. My lord, at the, as it were, macro policy level, it's a matter for Parliament. And as the appellant notes in its skeleton argument, in this case, Parliament was invited last year to amend the law to remove the nutrient neutrality difficulty for housing. And that attempt failed. Parliament rejected that legal amendment. So insofar as there is a macro policy balance to be struck, it's been before Parliament and it's been resolved against the HBF submissions. Insofar as the balance falls to be resolved in the instant case on the facts of this appeal, that's a matter which was considered by the inspector in the decision letter. Because the environmental protection here arose through policy and not through law directly, it was open to the inspector to find, and the appellant invited him to find, that the Ramsar protection imperative was outweighed by the material consideration of housing need. The inspector considered that balance very carefully, and his conclusion was that environmental protection prevailed on these facts. The reference for that, should your lordships want to look at it, is in the decision letter, paragraph 72 and onwards, supplementary bundle, page 85. And there is no challenge to that planning judgment before this court. So, my lord, to the extent that the intervener's policy arguments are relevant at all, they have been resolved against the interveners in unchallenged findings, both of the planning decision maker and of Parliament. The second point I can take even more briefly, my lord. In my submission, there is simply no basis in this case for the court to engage in a hypothetical analysis as to what the answer might have been had the law been other than it was at the relevant time. The court's heard no detailed submissions on that from any party. It hasn't had the benefit of any analysis from the planning court on this question to engage with, because it wasn't a live issue in front of Sir Ross. And perhaps most compellingly, it would be entirely academic on the facts. It would help not a jot on the resolution of the actual issue before the court. My lord, it is simply an issue which is best left to a case when the matter is live. This is not that case. Unless I can assist any further, my lords, those are the council submissions.
Thank you, Mr. Wilcox. Thank you. Thank you very much. So, Mr. Bowes, yes.
Hello.
Yes.
Well, I've attempted to contact Lord Banner to see the condition he's in, frankly, whether he can draft a reply in order to assist the court on a timetable to do that. I've not had a response from him on that point. And so all I would ask is that we have until 4 o'clock today to produce a reply, because then that would give Lord Banner ample time to do that. And if he's not able to, then I'll be able to produce it by that time.
Right, well, thank you. The court is very grateful to you in anticipation of that if it becomes necessary. So thank you. 4 o'clock. 4 o'clock. It seems to us, Mr. Moores, Mr. Wilcox, that that request is reasonable in the circumstances.
Absolutely.
And a deadline of 4 o'clock seems appropriate given the constraints and pressures.
It does, certainly. And there was one outstanding piece of homework, which was the statutory provisions, the regulations dealing with applications to for approval. We'll take the lead on that and produce it for Dr. Bowes and Lord Banner to agree, given that they're occupied with their reply, and that will be by 4 o'clock today, if that's acceptable.
Well, that does seem suitable, yeah. There was only one other request, not even a request, actually, just a question, over the Sizewell C case. I don't know whether that's been taken any further. Probably that there hasn't been.
I think that those behind me have been looking at the judgment, and if again the court would allow us until 4 o'clock to discuss and review, and if it's relevant
to those.
Yes, as my lord knows, I may have some familiarity with the content of that judgment, having been in the case, and I will liaise with Lord Banner, and if there's anything that we think is helpful to the court on that.
Yeah.
The court will know, of course, it was on a slightly different issue, which is about the scope of a project and then the scope of cumulative assessment. But
of course,
if there were useful obiter remarks in that case that will help the court resolve these issues, well, of course.
Yes, you were in that case.
I was indeed.
Yes, I'm so sorry that I hadn't remembered.
No, not at all. I didn't speak, so.
Well, forgive me for not remembering. I should have remembered.
Not at all.
But that would help as well. So those are all the loose ends, I think. Right. Well, subject then to all of that, the hearing will conclude now, and effectively the reply will be a reply in writing, which is after the hearing. You've given us plenty to think about already, and no doubt there will be more to think about in the light of the reply as well. We're going to reserve our judgments. In a normal way, a draft of our judgments will be circulated to the parties for typographical and any minor factual corrections. No re-arguing of any substantive point, as all of you know. At that stage, it will be incumbent on the parties to agree, if they can, a draft order. If there is any disagreement about the content of that order, submissions should be made to us at that stage, please. And judgment will be handed down in due course in the normal way. No attendance required. One thing to add, which I would stress if I may, please, there will of course be the normal embargo on that draft judgment. That embargo must be heeded. There will be consequences if it is not heeded, as all of you will appreciate. Thank you very much.
All rise.